Please be seated. We have three cases on the calendar this morning. We intend to take them in the order they're listed. After the first argument, we intend to take a 15-minute break, and we invite you to join us in the Commons, which is through the doors to your right, for coffee. I trust that all of the people who will be arguing today have had the workings of the clock made known to them. It's always been a mystery to me, but I assume you're familiar with it if you're the appellant and you want to reserve time for rebuttal. You just need to keep track of the time on the clock, and when it gets down to where you want to reserve that amount of time, you need to stop. The time that shows on the clock is your total time. Okay? The first case is Smith versus Gulf Coast Hospital.
I'm going to reserve 10 minutes, Your Honors. May it please the Court, Mike Valen for the appellant. The JCC erred for two reasons in this case. First, she departed from the stat fee based solely on hours and hourly rates. Under Alderman, that's a reversible error. You cannot depart upward or downward based solely on hours or hourly rates. Second, and most importantly, she ignored her own findings of fact. She found four of the factors neutral, including time and labor, and two positive. That supports an award of the stat fee or an increase in the award of the stat fee, not a downward departure as she did substantially. Her conclusion was therefore in direct conflict with her own findings of fact. That is the most important lesson to be learned for this case. The stat fee alone, Lee Engineering made perfectly clear, is an inappropriate starting point only. Starting point only. It's presumptively correct. But then you must analyze all of the six factors. I realize those factors are no longer codified. They were at the time of this case, however. And so
we're using the 99 version of the statute?
I believe it's 97. It's before the 03 changes that removed the six factors. But Lee Engineering is still good law, as made clear by the Murray decision recently. That's the cornerstone of that opinion, as a matter of fact. So the JCC must consider all the factors, and the purpose for that is to provide a record for review. Lee Engineering lamented the fact that there was no record for review when fees were being awarded simply by stipulation and by stat fee. So the stat fee in itself is an abstract and meaningless number. Let me give you an example. $500 stat fee may be excessive until you bring in the context of the statutory fees, time and labor, contingency of the fee, the amount of benefit to the claimant. A $50,000 statutory fee, on the other hand, may be inexcessive when viewed in the context of all of the statutory factors. The goal, Lee Engineering 1968, is a reasonable fee for services rendered. May depart up or down only if manifestly unfair after having reviewed all of the statutory factors. That was not done in this case. It was therefore an abuse of discretion. The case should be reversed and the statutory fee awarded. Thank you.
Thank you.
Good morning, Your Honors. My name is Tracy Hyde, and I'm here on behalf of Gulf Coast Medical Center and their servicing agent, Broadspire.
Ms. Hyde, would you distinguish the Alderman decision for us, please?
I can, Your Honor. The Alderman case, this court decided that the downward departure was not justified. This court stated that it did not feel that the factors cited by the judge were enumerated well enough or were not justified enough to support the downward departure that the judge in that case made.
Was the decision in the Alderman essentially that it appeared that JCC had awarded a fee based principally on hourly rate?
It did seem so, Your Honor, but I think the court made clear that in the decretal portion of this court's order that it was under the circumstances. And I believe Judge Padovano authored that decision and discussed in great detail that this was a case of first impression before the appellate court. The case was defended not only at the JCC level on numerous occasions, but also at this level on several occasions, and even the Supreme Court. The amount in controversy was an extremely large amount for the claimant.
The issue that went to the Supreme Court was a different issue.
It was, Your Honor. But it was discussed in the context of the novelty and difficult complexity of the case, the amount in controversy, the time and labor required. There were many more positive factors in the Alderman case than are found here.
Were there really? I thought there were 3 in each case.
Well, I think it's weight, though, Your Honor. It's a question of the...
Well, were there more positive factors in Alderman? Or
Than
were there the
in
same
this
number?
case? There were the same number. But I think it goes to weight, Your Honor. I mean, in here...
What did using the statutory formula in the Alderman, what did the fee break down to per hour?
I don't recall the number of hours claimed by the attorney, but I know the statutory fee in the matter was $63,000 reduced to $23,000 by the JCC.
Well, according to the opinion, it broke down to $847 an hour.
I do recall reading that,
What
Your
did
Honor.
it break down to here?
Depending on the various, well, there were several different scenarios.
Using the one most favorable to the claimant.
The one most favorable to the claimant, Your Honor, would have been, I think, $450 per hour, $458.
So significantly less than an Alderman.
It was significantly less, Your Honor, but the judge eventually found that the amount of hours that were actually expended in this matter was about half of what was originally claimed.
Now, she relied exclusively on the Transworld Tire case?
She mentioned that in her order, yes, sir.
Who was the appellant in that case?
In the Transworld, Hagnes.
But was it the claimant or was it the employer?
It was the employer carrier.
And they were claiming the fee awarded was too much.
Yes, sir.
And we affirmed.
Yes, sir.
What was the hourly rate based on the statutory figure in that case?
$1,700 per hour, Your Honor. The cases as the judge is required to award a reasonable fee. And if a low amount to a claimant's attorney is manifestly unfair, the courts mention time and again in the appellate decisions manifestly unfair. So if $4.48 an hour is manifestly unfair in one case, in the Jackson v. Ryan Steakhouse case that came out just last December, discussed $40.29 was manifestly unfair, then I think the fees at the other end of the spectrum are also manifestly unfair. And it's the judge's requirement or the judge's duty to award only fees that are reasonable.
Well, I understand that, but how did she get from, okay, this figure is manifestly unfair down to $200 an hour as if it were an hourly billing case? How do you get from there to here?
Well, the judge below did articulate each of the Lee engineering factors when she issued her opinion. I think most of the cases that have come up in discussion between the briefs of the appellant and the appellee are remand for the judge to make clearer findings in the articulate their findings from the Lee engineering case. So the case wasn't difficult or complex. It didn't preclude other employment. The fee customarily charged in the vicinity was $200 per hour, which was stipulated to by the parties. That the amount involved was a little positive, but that everything else was neutral except for the contingency of the fee. And I think the judge did explain and articulate in her opinion each of those factors and resulted in the downward departure given that the time and labor involved and the fact that it should have only taken or did take in her finding 35 hours to prosecute the case, resulting in the award of $7,000 at $200 per hour. So while in the end it was a multiplying issue of hours times an hourly rate, she did take the time to articulate each of the factors in Lee engineering in order to.
And she ignored most of them, didn't she?
I'm sorry?
She ignored most of them. She ignored the fact that this was a contingent fee case, even though she said that that was a positive factor.
I'm not sure what you mean by ignore.
She paid him based on hourly rate. She gave him no more than hourly rate, even though when he first took the case, he was facing the possibility that he'd get no fee.
That is true, Your Honor, but I don't think it was ignored. I just don't think that the positiveness of that factor, I believe she felt that the that the time and labor outweighed the positive factor of the amount in controversy and the contingency or certainty of a fee. I believe she felt it was outweighed. There's two cases that came out in 1989 that I think are directly on point here, where in both of those cases, one was pre-stressed decking court versus Medrano, where the fee awarded was a substantial downward departure from the statutory fee, but as long as and the appellate court found that the deputy commissioner clearly enumerated the statutory factors, and he indicated in his order that the fee was reduced to avoid an excessive hourly rate. And that was the only Lee engineering factor that was even cited by the appellate court, and so that was a substantial downward departure where the focus seemed to be on the hourly rate, even though the other factors were also considered. And the other, I'm sorry.
Go ahead.
And I was just going to point out the other case was even more substantial in the Pearson case, Fumigation Department versus Pearson, also from this court in 1989. The benefits obtained by the claimant's attorney were in excess of $5 million, and the stat fee on that case was over $1 million. And in that case, the deputy commissioner awarded $330,000 and said, quote, an attorney's fee award will not be set aside, or the appellate court, this court said, an attorney's fee award will not be set aside merely because it varies from the statutory rate when the order reflects an appropriate consideration of the statutory factors. So as long as the judge articulates the appropriate statutory factors, it is permissible, and has been so several times by this court, to have the primary focus be on the hours, as long as the other statutory factors were articulated.
The problem with this case is hourly rate was not the primary focus. It was the only focus.
In the end, it seemed that her decision was based on the number of hours times the stipulated hourly rate, but she did.
So I guess your argument has to be that so long as the JCC indicates that she's aware of what the statutory factors are, the award is bulletproof.
No, I don't think that's true, Your Honor. But I think that the appellate cases that have been discussed in the briefs and set before you for your reading, almost every one was a remand for the judge to make, or deputy commissioner to make, more specific findings.
Alderman was not a remand.
I'm sorry?
Alderman was a remand with directions.
It was directions to award the statutory fee. Yes, that's true, Your Honor.
And Transworld Tire was an affirmance.
It was.
Of a roughly $1,700 an hour award.
It was. But the cases, in the end, all seem to discuss the unfairness of the award in either manifestly unfair low or high.
The statute does take into account the risk to the plaintiff's attorney, the claimant's attorney, right? The contingency.
Yes, sir.
And so because it takes that into account, we could get, in a given case, where there is risk, a fee that computes to higher than the normal average hourly fee.
You could?
Okay, and it would be perfectly reasonable because that's the design of the statute.
Yes, sir.
We're compensating the claimant's attorney for part of the risk of achieving nothing, getting nothing, putting all that time in for nothing. So tell me, what part of this $200 accounts for the contingency or the risk that the claimant's attorney ran in this case?
That is the hourly rate that's available in the open market.
That's my point. Sort of a rhetorical question. The answer is nothing, right? Zero. Because what the claimant's attorney got was precisely the hourly rate. So one could conclude from that the plaintiff's attorney got nothing for running the risk of taking this case.
But the contingency works on the other end, too, Your Honor. For example, this court in 2004, and in the Davis case, which I believe you authored as well, $4.48 an hour was manifestly unfair because it didn't take into account the risk of taking a case that might have a low hourly rate. And that case was remanded because the judge awarded the statutory fee and the hours claimed by the claimant's attorney were uncontroverted. And in the remand, or in the decision of the court, there's no other discussion of the Lee engineering factors. It simply says $4.48 an hour is manifestly unfair. So if that's true, then the converse must also be true. That in each
$600 an hour is manifestly unfair?
In this particular case, I think it was, Your Honor, because the time and labor required was minimal, even though the amount of in controversy, the amount of benefits was relatively great. The case, it always works that way. When litigants go into the courtroom and the benefit to the claimant, such as it was in Jackson, the case that just came out in December, was only $200 to the claimant in the form of a mileage form, there's automatic agreement that $40 an hour was manifestly unfair. But they're never, in that sense, the claimant's bar always makes out in that sense, because everyone seems to agree that that's too low. And so
but the reason for that is because if there weren't some reward for taking these cases where there were small amounts of money involved, lawyers wouldn't take them.
That's true, Your Honor. I don't disagree with that. But there has to be something at the other end of the spectrum where at some point, and I don't necessarily know what that point is, and that's why I think it's case by case, and where this court in Alderman said under these circumstances, this case needs to be sent back with instructions to award the statutory fee because the downward departure wasn't warranted.
But didn't the legislature adopt this statute precisely to avoid the necessity of case-by-case evaluation?
But Lee Engineering requires a case-by-case evaluation, Your Honor, because the factors, with the exception basically of the hourly rate, are subjective.
But isn't the amount arrived at by applying the statute presumptively correct?
The starting point is the statutory fee, and that is the presumptively fair fee. Yes, sir.
And the reason for that is what? That the legislature wanted to avoid having disparate results in different cases, didn't it?
Yes, that's true, Your Honor, but I think disparate results end up that way anyway. You mentioned the Trans-World case in Hagness. It was the carrier appealing the $330,000 fee, and the result was the $1,700 per hour. And Judge Benton, when he wrote his dissent, commented on the fact that that very case had come before the lower court. It wasn't an appeal, but had come before the lower court just a couple of years earlier, where the plaintiff's attorney spent 26 hours getting a benefit for his client, where the statutory fee would have been $1,800, and the court said no, that wasn't sufficient remuneration, and they awarded 26 point whatever hours at $200 per hour, and he got a $5,300 fee for 26 hours or 23 hours worth of work. When this case went up on appeal, the judge below found that only 20 hours was necessary to prosecute the case, that resulted in $299,000 in benefits to the claimant, and that resulted in the $1,700 hourly fee that you asked me about earlier. Judge Benton in his dissent said there's not much standardization of fees when in one case for 26 hours worth of work the statutory fee was not reasonable and the attorney was given $200 per hour for a $5,300 fee, but suddenly $1,700 an hour in the same case for 3 hours less work is suddenly reasonable. And so I think the results are still very disparate, Your Honor, even taking into account the Lee Engineering factors. The judge has the duty to award only reasonable and necessary fees, and in this case it was only reasonable and necessary for approximately 35 hours worth of work to be done, and thus the judge departed downward from the statutory fee and cited her articulation of each of the Lee Engineering factors and decided that the two positive factors were outweighed by the need to reduce or depart downward from the statutory fee, and she did not abuse her discretion in this case. She should be affirmed. Thank you.
Thank you.
This was a heavily litigated claim. Those were the terms used by appellee at the trial level. The JCC found the time and labor to be neutral. That supports the statutory fee. Where she came up with 35 hours, I don't know. I didn't argue that point. We secured, on behalf of the claimant, over $400,000 in benefits. Over $100,000 in back benefits. The fee that she awarded was less than the stat fee on the back benefits. We've heard a lot of talk about the contingency and how it's always contingent. Actually, under 440.30, that is an exception to the contingency. You can obtain a non-contingent fee under 440.30, but certainly in most cases, these cases are contingent. There are degrees of contingency, however. A JCC, experienced JCC, seasoned JCC can, after hearing all the evidence, conclude that this was a very difficult case. The certainty of fee was not very great. That would be a positive factor. There are other cases, on the other hand, where it's obvious after the case has been tried that a JCC may find this was a no-brainer. You were pretty much guaranteed a fee. So contingency, there are degrees of contingency.
The JCC in this case found that was a positive factor.
She actually found the contingency to be a positive factor, along with the amount of benefit to the claimant, but then ignored those two positive factors. Without the factors, I don't know where we're at. We certainly wouldn't be here today. The factors are the most critical component of the analysis of a workers' compensation claimant employer carrier paid fee.
Let me ask you a question about the remedy.
Yes, sir.
Assuming a JCC abuses discretion in departing upward or downward from the statutory fee, is the proper remedy a remand for proper consideration of the factors, or is the remedy a remand for the imposition of the statutory fee?
I believe the latter, as you did.
That's not what you asked for in your brief.
Okay.
I think what you said in the closing line of your brief was...
During the initial brief?
Yes. There was no competent substantial evidence to support the JCC's award of less than a statutory fee. Therefore, abuse or discretion, the case should be reversed and remanded for proper consideration of the Lee engineering factors. Do you want this reconsidered, or do you want the statutory fee?
As in Alderman, Your Honor, that case reversed and awarded the statutory fee, and I think that's appropriate in this case as well. The briefs went through a bit of a metamorphosis. The initial brief arguing a competent substantial evidence standard of proof ended up being an abuse of discretion.
We had a long discussion about the proper remedy in the Alderman case, and the remedy, that discussion, of course, was not reflected in full in the opinion, but one of the problems is that if you remand it for a proper consideration and the JCC awards $225 in fees, you're right back here again with the same argument, and this could go on time after time after time, and so I guess depending on the case, that was why that came out the way it did in Alderman.
Absolutely, in agreement. One last point I would like to make. From the facts of this brief, you will glean one fact in particular, the costs in this case. We've talked a lot about the contingency nature of claimants' work and how we want to encourage claimants to take these cases. We had more $3,600 in costs in this case. That's more than half of the fee that was awarded in this case. We can all do the math. If you win 1 out of 3 of these permanent total disability cases, a claimant's attorney is not even breaking even. So that's a significant fact. So for all of the reasons that I have mentioned, the JCC committed reversible error in this case should be reversed and a stat fee awarded.
Thank you.
You're welcome.
Thank you both. We'll go ahead and take a 15-minute break now. We invite all of you to join us in the Commons through the doors to your right for coffee.